Good morning, good afternoon, and good evening. So we we welcome you all from wherever you are joining. You could be joining and listening to us from the US. You could be joining and listening to us from the Europe, India, and Australia. We have seen all of our viewers and listeners joining from each of these countries, each of these continents. So we welcome you all. And fantastic, happy Friday, Devarshi. How are you? How have you been?
Happy Friday, Vishwaroop. I've been fantastic. Really looking forward to this, and I'm sure there'll be a lot of learning for everyone who's joined in.
Well. We are super excited. We are bringing to you yet another episode and a session on key matters, key issues that a company faces while it deals with technology, and then how to navigate through these kind of issues. So today we are dealing with a fantastic, very interesting sort of an issue. The issue is, what are the kind of concerns, what are the kind of difficulties or nuances what are there when a SaaS company, a software as a service company, it works and it transfers data across border. So we have got two fantastic ladies joining us today with us. And as we will bring on the ladies, we have got Lisa joining us and we have got Siska joining us. And we will introduce Siska and Lisa in a brief while. So we will be speaking about what are the kind of issues, how to identify these issues, how to handle these issues, specifically focused on from a software as a service company when it transfers data between two countries. Okay. So without further ado, welcome, Siska. Good evening to you. Siska, can you hear us? Can you see us?
Yes, hello. Nice to join you both today.
Thank you, Siska, for joining in. And next, I'm going to bring in Lisa. Hi, Lisa. Good
Good
morning.
morning.
Good morning.
Good morning. Guys, thank you very much for joining us. Okay. And we are super grateful for having got your time to listen to you and then to understand this very nuanced approach. So at this point of time, we remain live on LinkedIn as well as on YouTube. And as I was telling the listeners before you joined in, that this is a very interesting topic that we are going to spend an hour time with. What is happening in that world of those SaaS companies, which essentially need to work and then transfer data between two countries internationally, cross-border transfers. What are these kind of issues which are happening over there? How to navigate through those kind of issues? We look forward to hear all those kind of nuances from you too. So thank you very much again from joining us, Lisa and Siska.
Thank you so much for the opportunity.
Thank you. So, without further ado, I would like to first go ahead and give a short introduction of Siska. Now, Siska is a senior consultant with Privacy 108. She has over 2 decades of experience as a corporate and tech lawyer, coupled with over 7 years as a privacy professional. Before joining Privacy 108, Siska served as the global head of data privacy, advisory, and engagement at ResMed. In this role, she led a global team in establishing and implementing a global privacy strategy and program. And very interestingly, Siska is also an adjunct assistant professor at Bond University Law School. Siska, thank you very much. We are so happy to have you.
Thank you for having me.
Thank you very much. So now without, and then I would like to go ahead and give a very short introduction of Lisa. Just hold on a second. I am just checking a bit of my connection. Please, can you give me a thumbs up if the connection looks fine from your point of view? Thank you, Devarshi. Thank you, Lisa. So, for Lisa, uh, I could go on for a long period of time, but here is a very short brief. So Lisa she's a manager and attorney, and she can code. She has got skills in coding in 7 languages. Okay, this I found it really very interesting to know that an attorney who can code, extremely interesting. And she has got numerous of the certifications. She is a fellow certified in privacy, FIP, CIPT, CIPM, CIPPU, CIPPE, as well as certified in HIPAA. and she has gone ahead and led multiple teams, and then she has gone ahead and provided advices in multiple different areas. Some of those are Grenintech, Deloitte, Optiv Securities, Oracle, and Accenture. So we are extremely pleased to have you, Lisa, and Siska and Lisa. Now, without taking any further time, let's get into the topic. Let's start discussing about what we want to go ahead and figure out. Devarshi, over to you. Let's get
Yes.
started.
Thank you so much, Visharup. Thank you so much. And thanks, Lisa and Siska, for joining us. Visharup did a really good thing, I mean, a commendable thing about introducing, you guys in such, short period of time, because we can go on and on, about your achievements. But so, for our audience's purposes and for our understanding as well. So we know that SaaS companies often, transfer data, between different countries, right? They could be collecting data from data subjects in 2-3 different countries, have servers in some other country, engineers working who have access to the data in a different country, right? So if you could, tell us what amounts to a data transfer, and what are the primary issues related to data transfer?
So I'll defer to Siska first, and then if that's all right.
Yeah. Okay. So I'm coming from the perspective of privacy lens in the Asia Pacific, even though I'm based in Australia. Just give a general view of transfer across that part of the world. A transfer is typically where data is transferred to a storage facility outside the jurisdiction or the country where the data subjects or the individuals are collected. So personal information being transferred like physically and literally to another location from where the individuals are based. Okay, so that's usually the most basic definition of it. But also a number of jurisdictions in this region also consider a transfer to have taken place, for example, where you might have software engineers accessing personal information in a country from another country. Okay, so that access or that ability to view or process information outside a country where that information is located can also be considered a transfer. And that, I believe, is very similar to how transfer is considered also in the European GDPR context.
And I'll add to that. So in my experience, the legal definition of a data transfer is the act of moving data from one location to another, but a data transfer can also take place between people, organizations, systems, and countries. Data transfers generally, from an operational perspective, refers to like the collection, replication, and transmission of large data sets from one organization or business units to another. Data could include things that are personal data, which are indirectly or directly identifiable to an individual, or can include confidential information, public information, and it really depends on the two parties or multiple parties that are sharing the data. But that's my understanding of what a data transfer is.
Thank you. And just to add to that, Lisa, I'll start with you. What are the issues, right? Primary issues with respect to data transfer, and when do these really trigger?
Sure. So I think we have to take a look historically at what's gone on under the scrutiny, not only of the law, but of the public. And a lot of people refer to Max Schrems and his pointing out kind of the inadequacy of the transfer between Europe and the United States. But what a lot of people aren't very clear about is actually the back history from that. So let's begin with, countries came up with laws to manage privacy. long ago, the United States, for example, came out with the Fair Information Privacy Practices, not principles, which was later formulated. And so, as the world was becoming more evolved and becoming more electronic and sharing data more quickly, organizations and countries began to realize that this mass transfer of data was going to impact them not only from an economic standpoint but from a cultural standpoint. And we take a first step at 9/11, unfortunately. From that historic event, we have the Patriot Act, which enabled the United States government to basically conduct surveillance and to use legal power in order to obtain information from cloud companies and the like, to understand and to identify preemptively terrorist activities. It was actually the country of Canada that first started to realize that something was going on here with the United States, because in Canada, a lot of consumers were getting these notices from banks, which had this blanket statement saying that, oh, by the way, your information or your personal data and your transactions could be subject to seizure by the United States. From Canada, you move on towards, there have been multiple, and so I've just got to kind of preface this with the fact that I'm a bit of a Netflix junkie. And there have been a lot of, I don't know if you've noticed this, but Netflix, as well as other streaming services, have done a lot of focus on privacy issues and historical privacy facts. So they do have something on John Snowden. And they do also have, there was a UK, a UK operative for I'm sorry, I'm very bad with acronyms and names, but there was a UK operative who identified that the United States was kind of conducting surveillance with the UK on individuals that were coming to the UK for a conference. And that's kind of what revealed the entire Iraqi scandal. She was under investigation for possible treason. She was cleared. I can't remember her name. Gosh. So anyway, so surveillance had been an issue that had been known to the European Union for a while now. Then in ZDNet, there was a journalist who started to investigate on cloud services that were being provided to UK universities, and the fact that all the data that was being inputted into by students through these cloud services was subject to the Patriot Act and this constant surveillance and taking of data, personal data, without a judicial process. And then from ZDNet, I mean, things kind of exploded. The prime minister, I think, or I'm sorry, an official of Germany kind of raised her hand and said, this is terrible. What are we going to do? And then eventually we came to Max Schrems, who really kind of focused and brought this to light to the entire world, for which we're pretty grateful. So the major issue has been kind of a control of rights. But if you take a step back, this issue of kind of unlawful seizure of your personal information has been going on for a while. I mean, the German state of Hesse enacted the world's first data privacy law. And then you think about in the news, Pamela Anderson and Tommy Lee, and then the instances of Kayla Laws. So for those that are unfamiliar, Pamela Anderson is a celebrity from a television series called Baywatch, and then Tommy Lee is the drummer for a band called Motley Crue. And they had made a sex tape, and they locked it away actually in a safe. They did not expect that video would become public, and what happened is in 1995, I think they fired their electrician, Rand Gauthier, and they refused to pay for the work that he had already done because they claimed it was inadequate. When Gauthier and his team came back to the project site to retrieve their tools, I guess they had an altercation, and that's when Gauthier, at least that's what he told Rolling Stones, that he was going to begin to kind of plan his revenge. So 5 days before Halloween, Gauthier broke into the couple's garage and stole Tommy Lee and Pamela Anderson's safe. It's not really clear who was involved in this, but amongst the personal effects that were in the safe was that sex tape video. He took possession of that cassette tape and took it to a pornographic studio and watched it. The owner of the pornographic studio who was Milton Ingley. This is where names are starting to work. Made copies of the tape and it destroyed the original. Ingley and Gauthier then shopped the tape around and finally passed the tape off to a gentleman named Louis Perenio, who ran an adult video production company called Arrow Productions. And they basically did it for $50,000. And then they started to hatch up the plan to kind of publish that video and make it available to the public on the internet. So Ingley and his associates then started selling the tapes online and around Los Angeles, and Pamela Anderson and Tommy Lee wasn't aware that this was happening until around January of 1996. And then they started to try to figure out, because they realized that the safe was gone. So this is like a few months after the safe had been stolen. Now, according to Rolling Stones, Tommy Lee and Pamela Anderson learned that Penthouse magazines had the tapes. And so they filed a $10 million lawsuit in 1996, that spring, for both a temporary restraining order and a permanent injunction. And for those that aren't familiar with laws, temporary restraining orders and permanent injunctions, it's not a lawsuit where you're necessarily getting damages and money, but a court is forcing an organization or an individual to do something. They also filed lawsuits against everyone that was involved with the tape, but they lost. Now you fast forward 15 years later. In 2010, Hunter Moore, he created this revenge pornographic site called Is Anyone Up? And it was for the whole purpose of publishing explicit videos of men and women who supposedly shared videos of themselves and others as a result of a breakup, and they would share intimate videos as sort of a revenge pornographic site. One of those users turned out to be Kayla Laws. But it was unbeknownst to her, because late in 2011, she took some topless pictures of herself. And in order to kind of free up space on her phone, she emailed it to her Gmail account. And so that she could have those photographs kind of stored there. Several months later, the photos ended up on Moore's site, along with her name, her city, and social media details. And she didn't understand, because she never shared this with anyone except herself and her personal Gmail account. She eventually told her mother, because she was, I think she was 16 or 17, and she felt like she was exploited, violated, humiliated, just like Pamela Anderson and Tommy Lee, and she wasn't sure what to do. Luckily, her mother had married an attorney, and so it was Kayla's stepfather, and he tried to use, at the time, the Digital Millennium Copyright Act, the DMCA, to argue that Moore had been publishing copyrighted photos without proper consent from the owners. And this is long before privacy laws, right? But they kind of ignored the takedown notices, and so the mother began to look at other options. She contacted the FBI, and they were kind of not really thinking of moving on this. And the mother, actually, she had been a former FBI lecturer. She had been a private investigator, and she had done other things, like she was a stand-up comedian, she was a cab driver, a singer, an activist, and many other things. So she used all her skills to try to figure out, because she suspected that someone had actually hacked her daughter's Gmail account, and that maybe the hacking was a little bit more widespread. She contacted about almost 50 victims whose photos were posted within about a 2-week period of her daughter's pictures being posted. And that's when she really started to realize that these photographs weren't obtained in any kind of meaningful way, but that it was actually a result of a third-party penetration and hacking into systems. With this information, she went to the Los Angeles Police Department, and then she unfortunately met what we term today as victim blaming. Well, it's your fault for having taken the pictures, to have them exist anyway, and she couldn't get any cooperation, and she continued to escalate her concerns to the FBI. And the FBI, again, kind of after several visits, wasn't able to do anything or wasn't willing to do anything. So she herself had to go out and basically create this file to convince that the FBI's that there was some sort of large-scale hacking scheme going on behind this website. Hacking charges were leveled against Moore, but then Charlotte Law's mother began to find herself, or Charlotte Law, who is the mother, began to find herself being degraded by all of Moore's followers, having threats, viruses put on her computer, and more hacking attempts. Regardless, Moore eventually took a plea bargain, which only included a $2,000 fine. And consider this, his website had hundreds of photographs of people who didn't know their photographs were there, that shared personal information about them, and he only had to pay $2,000. And he went to kind of a summer camp of jails for only 2 years. And of course, that was reduced with good behavior. And so that's what he got for this privacy violation. As a result, though, there was a lot of revenge porn laws, and that has been passed in 48 states and a lot of foreign countries because of this event. But I bring these things up because if you think about it, privacy and this invasion of your personal data and your rights have been going on for a long time. And it wasn't until more recently that government entities started to realize that this was inappropriate. And so the major issue, I think, in privacy has been this control of your personal information. Although we've always believed that in the United States that we had this right through unlawful seizures, Constitution, it is, of course, not expressly provided in our US Constitution. And it's been this kind of backstory of very long history. And more recently, with the rise of the internet, that folks have had to start realizing that this data that they've given up for a service is quite valuable, and it could have a major impact. And even though we're not celebrities like Tommy Lee or Pamela Anderson, we could be like Charlotte Law's daughter and innocent victims of consequences that we are unaware. And I think so. My long story to my final conclusion is that the major issue in privacy is not a matter of necessarily consents and notices and getting the words written right and making sure that data is available, but it's a matter of control and making sure that the individual whose data is being created about themselves, that they have that control. And now we've all become celebrities and have this right to control our persona, our reputation, our information, just like we've had in tort laws for hundreds of years for misappropriation of that information. So I apologize for taking all that time, but in my opinion, that is what the major privacy issue is today, which is all about control.
I mean, I'm just willing to take another 30 seconds to hear into this, because this is so interesting, this is so relevant, and most importantly, for anyone listening in, it gives a lot of context as to why we do what we do, or why it is done in a way what is done today. Thank you very much for giving this context and telling the story of what has led on to all of these laws, all of these standards being developed, and all of these kind of practices now being brought in. One question that comes to my mind at this juncture is that control comes from being within the jurisdiction, within the country, because it's likely that a person will be able to control, have a bit more better control over their data when they are localized. And then from there, this whole terminology of data localization, and then keeping the data within a certain country, this kind of has become very well known, predominant sort of a terminology. Can you spend a little bit of time, Siska, Lisa, if you can spend a little bit of time and maybe give a little bit of flavor about why do countries think that they need to keep the data inside, and if you have any different perspective from where you are in US, in Australia, what are the perspectives there? And then from a law point of view, what are these kind of factors? Can you, on a broad basis, can you tell people that if there were, because evidently the standards are different in different countries, so how are companies supposed to navigate this, right? It's a challenge. For a company to go into, say, functioning in multiple different countries, more than say 20 countries, to understand and figure out each of these standards in each of these countries is definitely a challenge. So two questions there. Why do you think this whole concept of data localization, keeping the data local, exist? And second is, how do you think companies can, on a broad level, overcome this challenge when every country has got these different standards, every country has got these different policies, laws?
Yes, I think I'll jump in there. To your first question, why do certain countries adopt data localization regulations or practices? I think there are a few reasons. One of them being, as Lisa has alluded to, there is this aspect of protecting local information or individual information of populations, for example, from outside interference, whether that be through surveillance or for other reasons that could pose risk to populations. And I speak of that in the context, for example, of health information, or in some contexts, financial type information, where they're considered in generally as sort of sensitive information around individuals. So countries are keen to keep that within, localized. The other aspect as well, I think, especially when I look around the Asia Pacific region, countries take decisions around localization for geopolitical reasons. For example, to promote or motivate local industries, local data centers, for example, local additional service providers that are required in the digital data economy versus overseas or sort of global entities. So that promotion of local versus overseas players in that space may be a reason towards localizing your data. And particularly when you look at India as an example, in the various iterations of its data privacy laws back in the earlier versions, there was quite strong data localization, and that got watered down significantly as we've moved forward. And there was commentary around why that was the case. We see data localization in countries like China in the Asia Pacific region, and particular rules around critical information, again, that higher order sensitive information. They don't want that to get into the hands of overseas players. So there's an aspect of being cautious and protecting sensitive information, but then there's also that just sort of that geopolitical and that potentially sort of economic aspect to it as well.
So if I could add to that, you asked, so your two questions, I believe, is why are governments kind of driving towards data localizations, and how can companies react appropriately in order to comply? So in terms of data localization, I'm sorry I keep going theoretical, but we all have this concept of a social compact or contract where we have to balance the rights to enforce, while at the same time you can't enforce it against someone unless they know that they're going to be enforced upon. And so that rises to this concept of jurisdiction. And so I believe a lot of countries are trying to expand their jurisdiction because, as we know, data is ephemeral, and so it's not a tangible asset like a server. And so they try to come up with this conceptual idea of how can we kind of capture the data so that we have jurisdiction so that we can enforce, being the backbone being that government agencies are supposed to be the representatives of the individual. You take with that, as Siska was discussing, you have to balance that against driving economy, right? Because you don't want to have so many requirements or so much harsh penalties that you're not going to you're kind of going to become not palatable to government, or I'm sorry, to private entities to come and establish in your organization. But just taking aside, technically speaking, I mean, this whole idea of data localization is almost impossible, considering that we're using SaaS providers who have to do things like backup
Exactly.
and disaster plans. There's geo redundancy, right? So in order to ensure that your data remains available, you've got to have it in two spots, right? And I believe Microsoft is the only one who has kind of claim that they will do this local redundancy, so that if you have a server that you're using in Munich, it will only back up to someplace in Berlin, right? So that it really does stay within a country. But with all due respect, like, people aren't realizing that in terms of geo redundancy, data that's in the United States is going to be backed up usually in a foreign country. And so people don't recognize that, but instead they look at the individual application provider, and they kind of aren't aware that while they're asking for backup and redundancy, they are not getting a local backup and redundancy. To your second question on how to address all these different various laws, what I've seen organizations try to do are two things: preemptive notices. So right now we've got all these standards, and we can all agree on the principles of the OECD and kind of generally a lot of the things that GDPR has spelled out for us. But the problem is, as a business, you can't always know what your stakeholders are going to want to do with the data, right? And so you try to capture that as broadly as you can. Against these regulations that say you need to be very clear and explain to the individual what those rights are going to be. So practically speaking, as an attorney, when you're trying to write a notice or a consent, you ask the business teams, what are you going to do with this data? And they're kind of like, well, we're going to do the things to fulfill the contracts. And then you ask the secondary question of, are you going to do more? And they're like, of course. What is that? We're not sure yet. Right? Probably marketing, developing products, and all that, but they can't get to that granularity. So a lot of
Right.
organizations, especially now with a focus on secondary use, I think have been working on trying to create these preemptive notices so that individuals understand your data is going to be used for the service that you're asking for, but we may also use it for marketing campaigns. We may also use it to develop products, but they can't get into that granularity because they don't know what those products are yet, because the teams are still working on it. So with that aside, then you talk about the other kind of controls or kind of ways in order to comply with all these various laws. And operationally speaking, I think there's a big focus on security, right? Because the more that you have control over your data, the more that you're probably going to be able to avoid liability under these laws. And so, I've seen a rise in tabletop exercises to ensure and test that the processes and the controls that you have in place actually work, rather than waiting for an event to happen. I've also seen other technical controls, like putting geo blockers on endpoints so that data actually can't go to another country, or it can't be accessed by a user at another country. But as we all can agree, no one can be 100% compliant. But these are kind of the actions and tasks that I've seen organizations take, which is, again, testing their security, having kind of technical solutions to control the data, and then having sort of this kind of preemptive notice. And I really am curious to see how organizations like the FTC is going to land on this, because they have said quite clearly, and so has other organizations, but the FTC has said since 2012 that in order to have secondary use, you must have affirmative consent. Does that affirmative consent require this very high level of granularity, or are these preemptive notices that are, generally speaking, telling the individual, we're going to use it for certain things, is that going to be enough? And I guess it's kind of a wait and see game, as we've seen in security generally, when you're supposed to practice reasonable security, and we don't know what that is until someone fails, or the FTC says you failed, and now you've got to do this. You have to encrypt social security numbers. You have to use malware. Security professionals are always kind of on the edge of their seat to understand, what is it that I have to implement because I think it's reasonable, but now we're going to wait and see what the government regulators believe is reasonable.
Yeah, I'd just probably like to also add, coming back to your question, Biswarup, is that we're not actually seeing a trend or an increase towards data localization. And there are varying degrees of data localization when we talk about data localization. You can have hard data localization, meaning data cannot leave the territory, and end of story. Or there's degrees of data localization to the extent that data can only be transferred to countries that have been pre-approved, for example, on an adequate country type basis, right? The country has corresponding privacy laws that are equal to the country that where the data is coming from. Or we can have data transfers provided certain contractual terms are in place, or and or technical and operational measures are in place. And when you look at a country like China, for example, some people, at a surface level, it might appear that data cannot leave China, but that's actually not true. And when you look down into the detail a bit more, data transfers can happen, except there are a few hoops you need to jump through, and it depends on the quantum of data. So a threshold, they take a threshold approach, which is unique, different, right, to other countries. But that's not to say that there's hard data localization in China. It's just that additional hoops need to be jumped through, security assessments, filing, with a regulator, for example, depending on the threshold. So I think countries are starting to realize that they themselves, either their governments or the people, cloud computing is a necessary part of how we work, live, and play today. And hard data localization is not likely to say necessary, possible, nor necessarily in the interests of countries. So they have to, it's in varying degrees and with different conditions. And these are the things that, as an in-house counsel or people working with tech companies, we have to navigate through and see how onerous those conditions are. And from a business perspective, then take an assessment and a judgment of, is it worth our while going into a particular country and setting up there if we have to, or jumping through the hoops to be able to provide our cloud service, our SaaS offering to that market. I just wanted to make sure that the audience sort of understands that we are starting to see countries, especially when I look at the Asia Pacific, providing ways to enable data transfer because they know that it's necessary. Like, coming back to Lisa's point, it's virtually impossible these days to have hard data localization.
And quite
agree,
honestly, you
yeah.
don't know if they've complied or how to enforce until there's been a breach incident, right?
Exactly.
And not only that, but speaking in terms of the Middle East, I've seen a lot of those countries like Qatar and Abu Dhabi and Saudi Arabia, like they actually do have laws that say you're not supposed to take this kind of data, primarily health data, out of the country without approval from like the Ministry of Health. But again, how do you enforce that until you have a breach incident and know that someone has or has not followed the law?
Yes, I mean there is just one nuance how it works. It happens is that there are some of these countries, they do not allow certain form of certifications being afforded to the devices unless they are completely disconnected from the cloud servers. This is something which I continuously see today. Some of these countries bringing in such kind of a technical isolation sort of a thing, as an initial measure to allow some of the devices to get into the countries, so that they can ensure the data which is processed is only processing locally. And I'm exactly speaking about the region that you brought up, Lisa. So
And
thank you that you brought that up. I just sorry, Devarshi, I just have one last thing that I wanted to confer upon is that um, this is also a very, I mean, one thing that I would like to underline is that there is a lot of geopolitical intent or geopolitical reasons why this is happening. And we saw exactly the same thing happening in India, where the first draft essentially had a very hard data localization requirement, and the final draft that got approved essentially says that you can transfer the data only to the extent you cannot to some countries which the government is going to say that you cannot, which again essentially puts the kind of power in the hand of the government to define which are those countries, which are those places, where the data transfer is not possible. So essentially creating a blacklist rather than creating a whitelist, how it is in for the GDPR. So
Well,
I mean,
I'm sorry, to balance against that, just a few days ago, the United States Department Bureau of Cyberspace and Digital Policy released their U.S. International Cyberspace and Digital Policy Strategy. And that was actually focused on maintaining a very open, interoperable, secure, and reliable internet, as well as trusted cross data flows. And just generally speaking, what they were thinking of is starting to offer, like you said, a data privacy certification that's backed by like relevant authorities, like the Cross-Border Privacy Rules Forum, which includes countries like Australia, Canada, Japan, the Republic of Korea, Mexico, the Philippines, Singapore, and Taiwan, which is supposed to facilitate data flows, right? And then part of the strategy is to kind of address privacy concerns through protective measures that are going to at the same time facilitate this cross-border data flow through mechanisms that are supposed to kind of work towards improving interoperability. And so that harmonization that you were speaking of between the the EU US data privacy framework, the OECD Declaration of Trusted Government Access to data held by the private sector, and the Center for Strategic and International Studies data free flow with trust. There's supposed to be continued work on clarifying application of the 2018 clarifying lawful overseas use of data, the Cloud Act. And there's supposed to be some sort of joint development and harmonization and mutual recognition of rights that is supposed to kind of manage data governance and digital trade through mechanisms such as the OECD, the G7, and other international efforts. And so, I think you had actually been correct in saying like there has been this move towards data localization, and that's proven literally from today's the 10th, from 4 days ago when the United States released that strategy.
I mean, this is, yeah, no, this, I mean, all great points. And, I can think of, multiple examples of these thresholds which need to be either adhered to in order for you to transfer. Like Central Asian countries will have a server where the primary data has to be residing there, and then you can transfer. India has something related to payment data, which they say that it's hard localization. But okay, you can process it outside as long as you can delete it in real time. So that's quite interesting where where this concept of data localization is heading. And also, Lisa, you also touched on this, and it was a great segue into the next portion that we want to proceed to. Is could you tell us, what are some of the best practices that these companies could have in order to or follow in order for it to transfer data of the of the data subjects outside, outside their country? And what are the statutory or contractual requirements in order to do that? And because, again, Lisa, you touched on this, what are some of the extraterritorial jurisdictions of, or extraterritorial approaches of some of these laws, privacy laws?
Sure. In terms of best practices, there's so many, but I'm going to focus on one that I think a lot of people would agree is almost like that silver bullet, which is encryption, right? Because if you look at a lot of these privacy laws, there's always kind of a safe harbor or an exemption to encrypted data, including breach notification laws, especially in the United States. I would say all 50 states, have this exemption. Oh, if it's encrypted data, it's fine. You don't have to report it. You don't have to notify. But let's talk about encryption, right? So I will be speaking at IAPP this fall at the Privacy, Security, and Risk about quantum computing and how that's going to impact encryption in general. So just on a high level, encryption is based on prime factorization, or on complicated math that's really focused on prime numbers, right? And so today's encryption, it's really difficult, like RSA, because they're based on algorithms based on prime numbers. And so it would take today's traditional computers almost years to be able to break the encryption that we have today. The problem is with quantum computers, basically super fast computers, they can do the work of a computer 20 times faster because they're not working on bits, ones and zeros, but they're actually being able to almost instantaneously figure out each code set, or each number that's used or has been quantified for that encryption code. So anyway, that's along the lines. But taking the fact that encryption is at risk, there are a few kind of encryption techniques that should be explored, like homomorphic encryption, right? Where the data remains encrypted while users can actually play with it. The problem being, though, that it's very slow and it's actually pretty costly, but I think it's getting a little bit faster. So there's one practice, is looking at homomorphic encryption and encrypting your data at rest, in transit, and even at use with homomorphic encryption. Statutorily, I just, and contractual requirements, how to meet that, right? I think the biggest hurdle that a lot of organizations find is data deletion. You kind of touched upon that, because as most people should know, it's impossible to delete data. And there's so many reasons why, right? Some data literally can't be deleted unless you pulverize, because you've your laptop and your hardware. And taking that aside, the most difficult part about deleting data is actually finding it, because there can be versions of it everywhere. Now I'm just gonna pin, screenshots that people may take of data, like, a customer profile. They may be like, oh my gosh, it's Pamela Lee Anderson. Let me take a screenshot and have it in my phone. Those you're never going to be able to find. But what today we do have certain technologies and certain methodologies that will help you find that data. And so what I'm referencing is what I've spoken about previously at other places, is the data vault methodology. It's not a single tool. And the data mesh methodology. So just touching upon that very briefly, data mesh is this concept of today, IT is in charge of the data. So they're in charge of building the architecture, but they're also in charge of kind of managing things like access controls and data sharing and role-based, all of that. And that's really kind of a huge burden, because it's really the domain owners, the legal department, marketing, corporate finance, to really understand what the data is going to be used for. And so data mesh takes that responsibility from the IT department and moves it over to the domain owner, so that the IT department doesn't have to guess what each of these departments will actually want. You combine that with data vault methodology. And again, in the most simplest terms, data vault methodology is about cleansing or kind of categorizing the data before you release it, and then adding a bit of like a security key code onto that data. So as I give data to Siska, right, when she makes a copy of it, that copy will have that key code number, or that kind of identifier, so that if you do need to find the data, to delete it, to retrieve it, to modify it, or to enable exercise of any of these privacy rights, all you need to know is that key number, and then it will find all the data supposedly on devices, on platforms, everywhere, so that you can actually find that data. It's not a perfect technology, and I can't really speak to it as well as my friends over at Skyflow, who I think is one of the leading data vault methodology companies in the world. And I only say that because they're very transparent about how data vaults cannot actually be applied to unstructured data, and other nuances that they're aware of that I cannot speak about technologically. So I guess that in terms is my idea of best practices, is the encryption, especially homomorphic encryption, and considering data vault architecture methodology, as well as these other kind of nuances, and being prepared for quantum computing, which many have laughed at because they think it's not coming very quickly, but many have changed their timeline from 10 years now to 5 years, and some have even said 3 years. So that would be my recommendation on best practices at this point.
And Siska, if you could touch upon the extraterritorial jurisdiction of some of these laws, and how, let's say, if there's a contractual, let's say a data processing agreement like signed between the SaaS company and let's say their vendors, subcontractors, how are they really enforced? Which laws are the laws of the data subjects enforced? Are the laws of the where the controller has been registered or incorporated, is that applicable? How do we go through this when?
Yeah, no, great question. And I think really at a practical level, when we're talking about enforcement, there are a few things. Obviously, if you in a number of countries, and again, I'm talking around my experience in the Asia Pacific region, a data transfer is generally speaking permitted if, for example, you have consent of the data subject involved. Now, the question of consent is a complex one because the level of consent required is going to differ among countries, and it's certainly coming to the question that we have from one of the audience members, be quite different to perhaps what meets consent, explicit consent under the GDPR. But that aside, as one legal basis to transfer data abroad, the other one is if there's a contractual agreement in place with the recipient of the data in the other country, and there's contractual obligations. So coming back to your point, Debashi, around, well, what if there is a breach of the contract there? What's the governing law and how do you enforce that? So the governing law is going to be what's specified in your data, in your contractual agreement, whether that be called a data transfer agreement, or it could simply be the contract of service with a few clauses in it dealing with handling of data. And so then you're going to come back to sort of the international laws or conflict of laws around how to enforce. And that can be a tricky process, just like it is when you come to, for example, try and sue someone for breach of a confidentiality agreement. What are you hoping to get out of that? What's the quantum of your loss, your damage? How do you quantify that? And then what are you prepared to spend through court to actually claim that back? Now, you're going to be, as an organization, you're going to be motivated to pursue action against a recipient who's breached your agreement, depending on the ease of regulatory enforcement, the governing law aspect, but also depends on the penalties that are under the governing law of the country you're in. And in the Asia Pacific, for those of you who work in that region, you have to take a step back and go, oh, it's great. There's all of these countries popping up with data protection laws, some that are extreme and they're constantly changing or tweaking or new things coming out all of the time. But if you take a step back, in order for a law to be really effective, you do need to have all of the regulatory infrastructure in place to be able to enforce the law. You need to have a regulator that's well resourced, as they are, in Europe, to make examples of cases. So the regulatory enforcement risk is something that you should consider. And in our part of the world, people typically say, oh, Japan has a very robust privacy law. Well, in actual fact, if you scratch a little bit deeper, there are some holes in that privacy law that do actually make it a little bit more, data friendly, shall we say. But then when you look at their regulatory enforcement record, there's virtually nothing to speak of. That's not to say that I will advise or recommend organizations to do what they wish with data, between, wherever their jurisdiction is in Japan. But the regulatory enforcement piece is something that you need to look at closely as well.
If I could, I'm sorry, if I could dovetail upon that, in order to enforce these data processing or privacy or processing agreements, I think a lot of what organizations do is create an audit clause so that they can actually audit. But that becomes an unnecessary legal negotiation as well as a risk to the organization that's being audited, right? And so it's really hard to get those audit provisions, especially from the big cloud providers, because Amazon is not going to let the person who's only spending $10,000 a year with them come onto their premises and ensure that their data is being managed the way that the contract says. And the reason I want to dovetail on this is, again, I'm sorry, I'm such a geek and I love quantum computing. So just again, a little touch of quantum computing. Today, our electrical impulses carry that data, right, information. And what quantum is going to do is you kind of zap a laser at it so that it becomes photonized. And the electrons and the carrying mechanism of that information start to have these attributes of physics. And the two attributes that are really important are superposition and entanglement. And what that means, and I've tried to explain this like a married couple at a wedding, but maybe I've got to change that analogy, so that when you have quantum computing, so let's traditional versus quantum. Traditional, I have a piece of information, it travels across the internet, and then Siska gets it. With quantum, what happens is I have a piece of information and I create it, and it instantaneously, almost like like you've seen in those movies, instantaneously is with Siska immediately. What's really great is that because these particles are so sensitive, if someone tries to intrude, for example, Siska and I will know quickly, and so we can change our encryption code so that it becomes penetrable or not penetrable to hackers. But that step aside, if you have messaging and communications based on properties of physics so that people are aware immediately of any change or any transfer or any information of data, think about the impact of that, because ultimately that means you don't need an audit. You will instantaneously know when your data is being transferred or misused the way that you don't want it to be used, because of these properties of physics that enables both the sender and the recipient to know that something is happening with the data. Then you don't need to have an audit. And I'm really curious to see if private sector is going to be supportive of this, if the government, especially the United States, the largest stakeholder that's investing in quantum computing, will enable the public sector to have access to this kind of technology.
Right. I mean, very, very interesting, and I think we are opening up a very new dimension into it. As to there is security protocols, there are mechanisms, there should be encryption, but then there are problems because quantum computing is going to disrupt that completely. One small bit that we have not touched upon is that what should a company do before they decide to go ahead and transfer data, before they go ahead and decide. So how do they analyze that, what is the likely impact of that sort of a data transfer? And can you give some examples of where there are requirements of going ahead and notifying an authority? In some countries, there are requirements of going ahead and additional consents being required. So, can you touch upon a little bit on that? And maybe that could be the last question of this session, as to what are the preparation mechanism for a company before they decide to go ahead and transfer the data?
Well, certainly, I know in my own experience having worked in house, and that I'm starting to see a number of companies resource in regards to, for example, vendor security assessments. So, if you're an organization that's procuring a service provider, a cloud service provider, then I'm finding that organizations are starting to get a little bit more mature or sophisticated in making sure that they properly vet and do due diligence before they go ahead with a vendor where the vendors processes their data overseas. Now, if you are a part of a cloud SaaS business that that this distinction between whether you're a processor or a controller is going to determine what level of consent you or notification or transparency you need to give to data subjects, right? Where you're processing their data, how you're processing it. And that distinction is not recognized in all of the jurisdictions in the Asia Pac, for example, but it is starting to get adopted in data privacy laws. So I think one thing is definitely to have, I've seen organizations have more resources put on due diligence, vendor security assessments, global certifications like ISO or 27001 or SOC 2. This is becoming almost, a requirement of SaaS. Organizations have to put money aside for that compliance cost, and that's not inexpensive. If you have an audit every is yeah.
And I think I would lean back on the data life cycle, right? And so before you're going to be collecting the data, figure out what you're going to do with it. And again, that's almost impossible because everyone is like, well, we're going to do this today and we're not sure of tomorrow, but we want to be able to do it, right? And that'll help you capture which laws, what policies need to be in place, if there are any policies in place that need to be updated and all of that. And then you shuffle through. But there are three areas that I think you need to really focus on, and that's your recipient, the data, and then, as you said, any notification requirements. In terms of the recipient, I think Siska has been very clear, like do a really good due diligence, make sure that they're an appropriate party to receive the data. So I won't go into much detail about that. In terms of the data itself, I think you need to look at the data. Has it been classified appropriately? Have you redacted and stripped it of information that shouldn't be going to the recipient? And so again, I would lean on things like the data vault methodology. Again, please contact Skyflow, not me, about, and if you need a contact, I'm happy to provide some, about how to kind of clean up and get the data ready before its distribution. And then in terms of the notice, right, it ultimately comes down to being able to communicate effectively to the individual data subjects as well as your client. Who are these recipients that are going to be getting the data, which becomes a bit of a nightmare for the website owner who has to publish these notices, because every time that you onboard a new vendor that's going to be processing or receiving your data, does that mean you have to update your website to add this new third party? And it's kind of been a little confusing because some organizations, they literally list their vendors. Others organizations have a general clause or description of that vendor. It's going to be someone who stores our data, but we're not going to tell you who. And it makes sense, right? Because from a security perspective, you don't want threat actors to know that your data is being stored with Microsoft or Amazon, right? And then, but also from an intellectual property and asset perspective, you don't want your competitors to know what you're using, and then they go and shop and see, oh, that's a lot expensive than the vendor we're using. So from a competitive advantage perspective, you don't want to list that in specificity. But at the same time, what's really difficult is as an individual, maybe I have a thing against a certain cloud provider. I don't want my data to ever be sitting with, Widget Co. So I want to know when you're using Widget Co. And again, to the audience question, like how can these general information meet the standards that are being enforced or supposedly enforced by government regulators? It's just a wait and see game, right? Is this enough? Is this not enough? Because they can't be prescriptive until there's a lawsuit or an investigation. And so it's kind of a wait and see game. We'll just have to test the waters. Is this general information, this general description enough? And like I said, we're just gonna have to wait and see what happens.
Perfect. I mean, I'm so happy we have. I mean, this is a topic which we can, of course, go ahead and take maybe another hour or maybe 1 hour more to go keep on getting deeper into this. But we will have to bring this to a closure today. So I would thank you again for all the knowledge that you have imparted with us. This is precious what you have imparted with us, and I truly believe that the listeners who would have joined in, and then we have seen a very interesting trend. I would like to share with you that we see the number of people joining in, listening in, and then revisiting the whole session, growing up as we move into the Saturdays and the Sundays. So
Well,
please
that
do
could be because we're talking so, or I'm talking so fast, and people are like, "Wait, what did she say?" Like, like so that's probably because of my foible.
no, I'm just. I mean, this is what we keep on seeing. So I was just going to make a one small request that if you can, if possible, if you can, keep an eye out on our page, and below the live link, there could be questions which come up, and we have seen this very regularly happening after the podcast session. So I would like to thank you very much, Devarshi.
Thank you. Thank you so much. Thanks, Siska. Thanks, Lisa. Thank you so much for doing this. I know this is Friday evening, really late for Siska, and the starting of the weekend for Lisa as well. Um, you know, to the audience, we will come up with hot briefings with new and interesting topics. So thank you so much for joining in. Thank you.
Thank you.
My pleasure. Thank you.
Remember, don't contact me about data vault methodology. Contact Skyflow. Or even Microsoft and Purview for data classification, because everyone who has Microsoft, you probably already have access to Purview for very cheap, and they can classify your data very quickly. Sorry, I didn't mean to do like a commercial solicit or commercial.
No worries. Thank you
I'm
very much.
taking note of those. So